welcome to today's CLE, Everything You Need to Know About California's New Joint Petition. I'm Jack McMorrow. I'm co-chair of the Beverly Hills Bar Association Family Law Section. It's a pleasure to have you here, and it's a pleasure to have our speakers today. The Family Law Section is sponsored by White Zuckerman, Borowski, Luna, Hunt, and SoberLink. White Zuckerman, Borowski, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to connect with them to discuss your specific accounting needs and learn how they can be a better service to you. Learn more at wzwlh.com. SoberLink provides objective, real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To help ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interests. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been a leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. All right, now I have the pleasure to introduce our speakers, Jennifer Weinstone and Jeffrey Jacobson. Jennifer Weinstone is a mediator and founder of Weinstone Mediation, Inc., known for her innovative strategy, compassionate listening, and practical approach to resolving family law disputes. With a cross-border legal background and advanced training in dispute resolution, she helps families navigate separation, divorce, and custody conflicts with clarity and care. Jennifer brings both rigor and humanity to guiding clients toward durable, forward-looking solutions. Jeffrey Jacobson is a state-certified family law specialist who has practiced family law since 1996, focusing exclusively on consensual dispute resolution. A recognized leader in mediation and collaborative divorce, he is known for his commitment to non-litigation solutions that prioritize dignity, efficiency, and lasting outcomes for families. Jeffrey has been consistently honored by a Los Angeles magazine super lawyer and is widely respected for his contributions to the collaborative practice in California. And I'll say that I'm aware that this joint petition has been a long time in the works. And so this is really exciting that it's finally here, and excited to listen in on this. So take it away, guys.
Thank you, Jack.
Thank you. I'm just going to pull up the slides. Thank you for having us. Get situated. Here we go. So everything you need to know about California's new joint petition. Just to start as an early primer, as Jack said, this has been in the works for quite some time. It was actually introduced just under 2 years ago by Senator Ben Allen, who Jeff and I partnered with on Senate Bill 1427. It was introduced back in February of 2024 and was approved on August 19th, 2024, when it was signed into law by Governor Newsom. It became effective January 1st of this year, so just exactly a month ago. And the law allows parties to initiate their case in a collaborative, cooperative manner in partnership through the joint petition process. The Senate Bill 1427 and the law amends Family Code Section 2330, which establishes the required content of a joint petition. So Family Code Section 2330 is the statute that says on a petition, here are the requirements. Parties must state certain facts as they can ascertain, as nearly as they can ascertain, like date of separation, date of marriage, children of the marriage, etc. Family Code Section 2330C now provides that in a joint petition, certain more limited facts, what we would frame as the uncontested facts, the truly uncontested facts, non-contentious, like date of marriage or who the kids are, will be listed on the joint petition, and then a list of issues that parties intend to resolve by agreement are pre-printed on the joint petition. It also amends Family Code Section 2331, which provides that on filing the joint petition and the joint summons, the service requirements are completed, and both parties are determined to have made a general appearance. It adds Family Code Section 2342.5, which Jeff will speak to in a moment, is distinctive from Section 2342. And this provides the procedures that govern the joint petition process, which is what we're going to talk about in more detail today.
So we want to start by clearing a misconception. This is not a joint petition for summary dissolution. Most of us are probably familiar with that process. It's actually a fantastic process and really is tailor-made for what I'm going to call no issue or limited issue divorces. In order to use the joint petition for summary dissolution, marriage has to be under 5 years, no children, no spousal support issues, limited property, and no real property, right? So the demographic of clients who can actually use the joint petition for summary dissolution is really, really limited. It's a great process because simplified forms, you literally submit a form at the outset, you're automatically divorced in 6 months. There are lessened disclosure requirements. It's a lovely process, but almost nobody can use it. As a result of the joint petition for summary dissolution process really being geared toward no issue or limited issue cases, it also doesn't have the protections of what we would call a traditional divorce, right? So there are no atros that go into effect. And like I said, there's a lessened disclosure requirement. So again, think of a joint petition for summary dissolution as a process which still exists, not impacted at all by the new joint petition, but one that can really only be used for no issue or limited issue cases. Again, you have to be married for less than 5 years, no children, no support issues, and very strict requirements as to small amount of property. And now we get to the new joint petition. And big difference is this process can be used by anybody. Doesn't matter how long you've been married. It doesn't matter whether or not you have children. You can have spousal support issues. You could be billionaires. Anybody can use the joint petition process. It also has all of the protections that we see in what I'll call the traditional forms, the FL 100, the summons, and everything that we've all been using for years. All of those protections, the atros, the disclosure requirements, nothing changes at all. And similar to a regular petition, a regular response, nothing happens automatically, right? A case is going to end in one of two ways. Either there's going to be a stipulated judgment or there's going to be a litigated outcome and a judgment based on that. I'm going to talk a little bit about what can be done and what can't be done within the joint petition process. But just to clear up that misconception, this is not a joint petition for summary dissolution. It is a completely different process.
And Jeff, just to add on to that, in terms of the amendments to the statute, there are ancillary amendments that were also made that clarify that when the statute is speaking about a joint petition for summary dissolution, where it previously just said joint petition, so that there is clarity when we're talking about one thing or another according to the family code.
Yep. All right, so I'm going to talk a little bit now about how the joint petition process works. And everything that I'm going to run through really tracks the new Family Code Section 2342.5, right? So if you see me talking about this and going through it, you're going to see the same things in 2342.5. We have some new forms. We have the joint petition form, the FL 700, new joint summons form, the FL 710, and those are filed with the court. If the parties have minor children, they're both required to fill out the FL 105 declarations under UCCJEA, right? So nothing changes with that. We then get to the question about filing fees. And when we were developing this legislation, working with people in Sacramento and ultimately the Judicial Council, we really didn't comment at all as to how local courts were going to address the issue of a filing fee. And we learned, just like everybody else, on January 1, how it was going to be handled. And at least the several joint petitions that I filed during the month of January 2026, the LA Superior Court is charging a single $435 filing fee. And that's it. A case gets started based on the joint petition. Like I said, declarations under UCCJEA, nothing changes. Just like any other divorce, the ATROs go in effect upon filing the joint petition, right? So all the protections that you have in a traditional divorce exist in the joint petition process. The disclosure requirements haven't changed one bit. Both parties are required to separately file declarations regarding service of declaration of disclosure. Nothing changes as far as the disclosure requirements. Within the joint petition process, both parties can propound formal discovery, right? So everything from interrogatories to requests for productions of documents. Within the joint petition process, nothing stops the parties from doing that. If the parties need to amend the joint petition, they're welcome to do so, right? Both of them are going to have to sign that amended joint petition. Because the joint petition has such a limited amount of information on it, and Jen is going to walk everyone through the forms, the only times I can really think of where there will be a need to amend the joint petition would be if there was a misspelling on one of the parties' names, if there was a mistake as to the date of marriage, a misspelling as to the children's names or date of birth. But those are really the only reasons I would see, for a need to amend the joint petition. And ultimately, I think the best way to explain it conceptually is think of it as a non-default stipulated judgment, right? Where one spouse files a petition, one spouse files a response, they both appeared, and a stipulated judgment, and the forms that go with it would track that entirely, right? Think of it as non-default stipulated judgments is really what we foresee as the endpoints when people start with a joint petition. So the next question is, what happens if people start with a joint petition and they're not able to reach a stipulated judgment? And when we were developing all of this, one of the biggest questions we always had was, how can we create an off-ramp that's really easy, that's not going to be expensive or time-consuming or burdensome to the courts? And this is what happens. So people can stay in the joint petition process until they need to seek judicial intervention, meaning someone needs to file a request for order. Somebody needs to file a request for trial setting. Even, a motion to compel or discovery requests. At that point, when you seek judicial intervention, that's when you're out of the joint petition process. And in order to do that, there's a new form. It's the FL 720, called a Notice of Revocation of Joint Petition. If one party fills out the notice of revocation, which of course they can do unilaterally, they also need to do an amended petition or an amended response. So if someone is designated the joint petitioner 1, they'll do an amended petition. If someone is designated as the joint petitioner 2, they'll do an amended response. For 2342.5 references that the order of proof is still that same petitioner and respondent, but instead it's based on the order that they filed the amended pleadings. There is a reference, by the way, to Evidence Code Section 320 which indicates that a judicial officer has discretion in terms of the order of proof and whether they want the petitioner or respondent to present their cases first. So there is some leeway, and that's very specific in the code. Once somebody files the notice of revocation of the joint petition, either an amended petition or amended response, the exact same rules go into effect for any response to an amended petition or response, right? So nothing is new in the new code sections or anything else with this process. Think of it as the exact same thing after two parties have appeared if someone does an amended petition or amended response. So keep in mind that if somebody does do the notice of revocation of the joint petition with the amended petition or response, the atros stay in effect. Both parties have appeared. Nothing will go by default, right? Because the parties have already appeared, atros remain in effect, the 6-month clock, jurisdictional clock for the effective date of divorce, none of that is at all impacted if there's a revocation of the joint petition.
So what goes where on the forms? As Jeff explained, these forms are incredibly simple. They'll take just a few minutes to fill out because there's no decision making at the outset, which is exactly the point. So this is what the joint petition looks like. You'll notice at the top it says use this form if you and your partner are married or registered domestic partners and want to divorce, dissolve your domestic partnership, or legally separate, and both agree or plan to agree on all issues in your case. Now, there is a small inconsistency that it's our hope will be revised on a further revision where it says, do not use this form if you disagree on any legal issues. Parties can disagree on legal issues, as it says above. If they plan to agree, if they are committing to try to get to resolution, that is all that is required. So that is a small inconsistency on the form, and it's quite clear in the statute, and it's clear in the info sheet and everywhere else. So we would encourage people not to concern themselves if there may be disagreement. If there may be disagreement, they can still use this form. Then they're going to fill out their information. So we have Wilma Flintstone as petitioner 1 here. If Wilma is represented by counsel, there's room for her lawyer's information below and lawyer's contact information. On page 2, petitioner 2 is listed. And again, petitioner 2's lawyer's information and contact information will appear there as well. If they are self-represented litigants, then they would just put their information and leave the lawyer information blank. Their date of marriage, is on page 2 as well, or if they are registered domestic partners, they would so state. Residence requirements, they're going to fill out on page 4. In most cases, it's going to be that they've lived in the state of California for the last 6 months and in the county in which they are filing. Of course, there might be other residence grounds that they may list. Legal grounds to use a joint petition, there's only one. So it's only irreconcilable differences. We couldn't see a circumstance under which parties would use a joint petition if they were seeking to nullify their marriage or if there was legal incapacity of a party or abuse or fraud. So only grounds for use of a joint petition, only grounds for divorce is irreconcilable differences. They're going to list their children, dates of birth and ages. As Jeff mentioned, each party is also going to fill out a declaration under the UCC JEA if there are children, if that applies to this case, and that will be attached to the joint petition form. And then we get to issues you agree on or plan to agree on, and there is no work to be done. So parties don't have to put TBD under date of separation. They don't have to determine the date of separation at the early stage, at the outset of their case. They don't have to state whether or not a party is seeking spousal support. Again, they could seek spousal support, or they could agree to an order for spousal support, or they could say that they're waiving spousal support. All of those are decisions to be made upon agreement. They are legally relevant issues in the case, but they do not need to make determinations or claims when using the joint petition form. Property rights, lawyers' fees, child custody. They may also check if they want a name change. They don't have to say what they are, who's asking for a name change or whether they're asking for a name change, but that is listed as well. And they can add any other issues as they wish.
I want to I want to kind of add on to what Jen walked everyone through on this item number 7, because in my view it's really central to everything behind the joint petition, right? So think of the current FL 100 form, right? Date of marriage, they ask for a date of separation. There's check boxes when it comes to legal custody. There's check boxes when it comes to physical custody, check boxes when it comes to spousal support, attorney's fees. I've been saying for years that those forms are really designed for cases that go by default. And the idea is when somebody starts a divorce case, many of them really just aren't in a position to select a date of separation. They don't know the legal significance of it. They may not understand the definition of it. You then get to the check boxes on the FL 100 regarding custody, right? What's the difference between sole legal custody and joint legal custody? Joint physical custody and sole physical custody. I think if you asked 100 family lawyers to tell us exactly what the difference is between joint physical custody and sole physical custody when you're checking off a box on a petition, you'd probably get a lot of very different answers. And people having to make these kinds of decisions at the inception of a process, like I said, unless a case is likely to go by default, it really goes to that question, why, right? What value is added by people having to make those decisions on forms? We know how this works, right? People can do amended petitions, amended response. They could do that up until the time of trial with the traditional forms. And we find that it's a huge stressor for people to have to make those decisions. For somebody to get served with a divorce petition where they see check boxes that say sole legal and sole physical custody, it impacts people and impacts the way a divorce starts, right? So we now go back to the joint petition and we look at item number 7 on it, where it just lists issues. People don't need to decide on a date of separation, or they don't need to make contentions on it. They don't need to make contentions on spousal support or a parenting plan. These are just issues that the parties intend to resolve. You can add more issues to the list, but it's really important to us that people don't need to make decisions, get anchored to decisions, react to check boxes on an initial form, which really isn't germane to anybody unless a case goes by default. So item 7, in our view, is big. So just to kind of recap where Jen has taken us so far, and she's not quite done with the form, the only information that needs to be provided are the parties' names. If they have attorneys, that'll be listed as well. The date of marriage, and the names and birth dates of the minor children. And that's it. There's no other check boxes or decisions that people need to make when filling out the initial joint petition form.
Yeah. And again, there's no need for them to make claims because these are cases that if they resolve within the process, they'll resolve with settlement. If they do not resolve within the process, then they have the opportunity to state those claims on their amended forms, on their amended pleading forms. So paragraph 8 talks about legal rights they are giving up by opting into this process. So they are giving up the right to be legally served with a petition and summons. Since there are 2 petitioners, no one is served, just like the petitioner in the traditional case, in the traditional process, is not served with his or her own summons. In this case, we have 2 petitioners, so there is no service of the summons. All the standard temporary restraining orders apply as soon as the form is filed. By filing the form, each party is making a general appearance. This means that the court is going to make decisions in their case and they agree to participate in the case. The day that they make the general appearance also starts the clock for the 6-month waiting period for other deadlines, including the disclosures deadlines. That's going to start the clock as soon as day one of the filing of the joint petition. So if it is day 59 and a party files a notice of revocation, on day 60, those disclosures are still due technically according to the law. It doesn't reset and provide more time. If one or both party later decides to revoke the joint petition and move the case to a different process, the date the joint petition is filed will be the filing date of the case, as I've said. And I think I just explained this about the court deadlines still apply retroactive to the date of the joint petition, regardless of whether it transfers out into the traditional process. At any time before the court enters a judgment, which in the joint petition should be a stipulated judgment or a judgment with an agreement, either party can file a request for order, and they then must revoke the joint petition and move into a different process, but they are within their rights to do so at any point in time before a judgment is entered.
Before Jen leaves the FL 700 form, a question that we've gotten is, why does this look so different from the FL 100? And when Jen and I were developing all of this, we actually envisioned what forms would look like. And we were educated that this is what the Judicial Council does after legislation goes into effect, and they're instructed to create new forms. So we kind of thought that, hey, this would be a simplified FL 100. They call it the FL 100J for joint, and this would, be like a one-page form. As we understand it, all of the new forms in family law created by the Judicial Council use kind of this plain language format, right? So it's more extensive. There's a lot more explanation on the forms. It's written on a level where, most people can understand it easily. So this is in that format. So I just want to address why this looks so much different from an FL 100, because this is really how the Judicial Council does forms going forward in this plain language format, which makes the forms a little longer for the most part.
And my understanding, Jeff, correct me if I'm wrong, is the traditional forms were created with the backdrop of a 12th grade reading level, and these forms and the new forms are geared towards an 8th grade reading level in order to be a more simplified approach. I think it's across the board though in civil. I'm not sure if it's just to family. I think it might be across the board that everything is moving towards this 8th grade reading level, but I could be wrong on that. Mm-hmm. So then we're going to have the signature notice of cancellation of rights. That is exactly the same as it is on the FL 100. This is the summons. There isn't too much to say about the summons except where that big orange arrow is, where you'll see it says the joint petitioners named below are parties to a formal legal proceeding and are immediately subject to certain obligations as a result. Read the information below and on the next page. This replaces what parties currently see on the FL 100, which used to be the only way to start a case, and it started with "you have been sued," which is incredibly jarring, incredibly aggressive and threatening, especially for two partners who are looking to do things differently and in partnership. So this is the big change on the summons. Of course, there's also a change in that both parties' information is listed. And the standard family law restraining orders are listed identical on page 2 to what we see in the FL 110. If in doubt at any point, the FL 700 info sheet provides all of the necessary information. So when in doubt, go to the info sheet. It explains what to do at what stage in your case. If you need to exit out of the process, it explains in detail how you do that. If you change your mind, can't agree, what do you do? It explains again in detail that nothing happens automatically. This is not a joint petition for summary dissolution. There is no automatic divorce at the 6-month run of the clock. In the event that a request for order is required, you know, here's how you exit out of the process. So it's very, very clear. It also states that if there is domestic violence, this may not be the form for you. We'll talk later about, what kinds of cases are appropriate for the joint petition and what kinds of cases are not appropriate for the joint petition. And if this is a case of domestic violence, they should be using the other form. This is the notice of revocation of the joint petition. So again, it's very clear. You're going to want to check the box of whether you were petitioner 1 or petitioner 2, because that is going to determine whether you file an amended petition or amended response. So you'll see over here, you're going to check the box for depending on who your party was. It does not matter in terms of how the case will proceed. So sometimes I know parties are, or lawyers are intent on filing the petition, on filing first so they can control the case. Again, if you were the joint petitioner 2 and you were filing an amended response and you file first that amendment, then your case is heard first at trial, again, subject to the court's discretion, which it has in every single case according to Evidence Code Section 320. Once the notice of revocation is filed, the other party has 30 days to file their amended pleading. And then these lists of these items from A to F under paragraph number 2, just again lists what we've already mentioned, which is that the restraining orders on the summons are still active. Parties may be ordered to pay support, lawyers' fees and costs, et cetera, et cetera. This is all proceeding now as the traditional case.
All right, so I'm going to talk a little bit about who can or should use the joint petition. So going back to something I said before when comparing it with the joint petition for summary dissolution, anybody can use this, right? There's no restriction as to the estate or the types of issues. Anybody can begin a case with a joint petition. And the next question is, who should use this process? Well, what we're calling the likely twos, right? People who are going into their divorce, they're cooperative with one another, and they fully intend and expect to reach an agreement without judicial intervention. They really view the divorce process as a partnership, right? The paradigm of one party being the petitioner, somebody getting served, somebody filing a response, this doesn't feel right for them. And they fully intend to stay out of court. And this process is really made for them. What we're calling the second category, the want tos. Again, people who, like the first category, are committed to resolving things without going to court. Maybe they don't have any thoughts of an agreement or developed agreement. They just know they want to stay out of court. And, an initial commitment by filing a joint petition, it does impact the likelihood of them reaching an agreement. I assume that we're all family lawyers or professionals dealing with family law cases in this meeting. And I think we've all seen examples of divorces going sideways by virtue of somebody being surprised or by virtue of somebody reacting to a checkbox on an FL100 form. All these things really impact people, and being able to do it in, an easy, non-threatening way is really what the joint petition is about. The third category we're calling the don't know what to do's. A lot of people who are getting divorced really have no idea what the end point is, and they're not even clear as to the process they're going to use. All they know is they, at some point, want to be divorced. And for those kind of people who aren't quite clear the direction it's going in, they're comfortable filing the joint petition just to start the case in a non-threatening way, right? Even very basic things that, as a family lawyer for almost 30 years, I don't often think about, that there's a real meaning to a lot of people as to who's listed as the petitioner and who's listed as the respondent. someday our kids are going to know that you're the one who filed for divorce. I think we've all heard something to that effect from clients. So being able to start on an equal playing field, on an equal level, where we have joint petitioner number one and joint petitioner number two, I think really does go a long way in doing that. And the last category that I would mention that we're calling the no looky loos, but these are really people where privacy is a premium to them. They don't want a lot of information on initial pleadings, right? You don't have to be, an influential person or a celebrity to want to use a joint petition. But a positive byproduct is someone can file for divorce in a way where it does a number of things. It shows that people have a real intention of resolving things without litigation. They don't need to make contentions regarding a parenting plan or spousal support or even a date of separation. And it really fits well for that demographic. At the end of the day, they're ultimately going to have a stipulated judgment, and that's going to be on the public record. But a way of starting a divorce in such a way where I'm going to use the word public messaging, is nothing other than these people are filing for divorce and really nothing else beyond that. And for some people, that's a very meaningful thing. So the privacy component, we all know this is all on the public record, and it really does make a statement for a lot of people to start with the joint petition process. The next question is, who shouldn't file this joint petition? And the obvious one is anyone who's likely to require judicial intervention. If somebody knows going in that they're going to have to file an initial RFO for support or temporary parenting plan issues, this isn't the process for them. I would say that demographic is also one where it's a lot harder for both parties to align on even filing these joint petition forms. So there's always going to be a litigation demographic. There are people who are going to need litigation, and there are going to be people who this is just not going to be a great fit. Cases that involve domestic violence, right? For a lot of reasons, this process isn't a great fit. If for no other reason, there's a likelihood that they're going to need domestic violence restraining orders, at which point they would have to revoke the joint petition process anyway. Anybody who has questions about jurisdiction, they shouldn't use this form, because once this form is filed with the court, once the joint petition is filed with the court, they've consented to jurisdiction, they've appeared. No one's going to be able to make arguments about Los Angeles County not having jurisdiction or wherever in the state of California this is filed. So that's not the demographic. And in the advisements right on the FL 700, it talks about, both of you are appearing and this is it. You're waiving, any rights to service or anything like that. So that's really the demographic who shouldn't use it. Before we go off this slide, I just want to make another comment. Over the course of several years when we're developing this, we always ask the question, how can we create a process that has the same protections, where we can tell people that if they start with a joint petition process, they're not waiving any rights. And we worked really hard to do it in such a way where there was an easy off-ramp. We talked about the fact that people can propound formal discovery within the joint petition process, but really wanted to make it such that, no one would regret filing the joint petition. Okay, whatever, you fill out the FL 720 notice of revocation. It's a few check boxes. You then do an amended petition, amended response, which people, of course, can do without leave. And away they go, right? They can, litigate this just like any other case, but there really shouldn't be any prejudice as a result of starting with the joint petition.
So why did we need this law? Why did we need these forms anyway? And our theory and what we believe the joint petition will do is it has real opportunity to revolutionize California divorce and have significant impact. And, in other presentations, we've always started with the impact first and then gotten to the forms. But I like that we're ending with the impact in this presentation, because really what the joint petition does is it provides the infrastructure to support settlement, which is consistent with a number of things. So the first thing that it provides support to is legal policy. This is the policy that exists in California law. It says that the peaceful resolution of disputes in a fair, timely, appropriate, and cost-effective manner is an essential function of the judicial branch of state government, and many disputes can be resolved in a fair and equitable manner through less formal processes. Legal policies that seek to promote resolution and positive parenting relationships, minimizing conflict, are lip service to the extent that we don't have the forms and procedures to support them. So the joint petition really fills that gap. It creates supporting infrastructure for legal policy that already exists to encourage the use of alternative processes, less formal processes, less contentious processes than the adversarial litigation process.
Yeah, I was scrolling through the Q&A, and somebody asked the question, what was the impetus for this? And Jen just walked us through the public policy for the state of California. And by the way, CCP 1775 that, is on the screen right now, that's been in effect for about 30 years. I mean, this is nothing new about our state having a really clear policy about wanting to keep people out of court. And this is part of the CCP. It's not even talking about family law and, cases involving children and all the hugely important things that are at stake when people, are getting divorced. The real impetus for this project is that the old process didn't fit for most families, at least the way I see it, right? FL 100, I've said a number of times, are really designed for cases that go by default. But in the state of California, except for the rare people who would qualify for the joint petition for summary dissolution, everybody needs to use the exact same process. There's a form of a joint petition in lots of other states in our country. But for whatever reason in California, there's always been that disconnect between the public policy in terms of keeping people out of court and the processes, at least to begin a divorce, right? So the joint petition process addresses at least part of it by creating a way for people to start divorce that just simply didn't exist before. So the impetus really is, look, I'm a full-time mediator. I stopped going to court about a decade ago. The only thing I do is mediation and a few collaborative cases at any given time. But I'm basically a full-time mediator. And every time I'm explaining to clients the FL 100 forms, and I would file the petition and response concurrently, so they're both essentially appearing at the same time, I always felt like I had to explain a lot of things away on those forms, right? Why do we have to check off these boxes for legal custody and physical custody? What if we have no idea what our date of separation is? What if we have no idea what options we have for spousal support? I oftentimes had to explain it away and say, look, this form just opens up a case with the LA Superior Court. Nothing happens automatically. And the end point in our process is to submit a stipulated judgment. All those things are now done through a joint petition that actually is compatible with CCP 1775 and the public policy. So the impetus here was really to create something that didn't exist, in our opinion, was sorely needed in our state.
The second reason is legal theory, and this goes to fundamental principles of negotiation theory and practice. Now, whether you've studied negotiation theory or the psychology of conflict, or whether you have the intuition over from your experience, from your years of practice, we know these things to be true. So we know that how we start a case matters. We know that the initial trigger points can have significant impact on the outcome and on the ultimate result. So we've got a quick little social science corner. This is just one example. So we chose an example for the Drive Safely campaign. That was a research study that was done back in 1996. Again, it's one of several examples. If we had a lot more time, we would go through them all because it's fascinating. So this was a study that we chose because it was done in Northern California. And researchers went around to homeowners in a upscale Northern California town and asked them if they would mind putting a sign on their lawns that said drive safely. Now they showed them a photo of this sign. The sign was huge. It was obstructive of their beautiful homes. The lettering was kind of ugly, so it just looked bad. And the most homeowners, not surprisingly, 83%, said no, I'm not putting that sign up. However, in a similar neighborhood, the majority of homeowners, so exactly the same demographic, the same upscale type of neighborhood, homeowners asked to erect the exact same sign, showed them picture. Most of them, 76%, said yes. So what was the difference? Well, 10 days earlier, homeowners in the second neighborhood were asked by a different campaigner, different set of researchers, to place a tiny 3-inch by 3-inch postcard in their windows that said, drive safely. 10 days later, when different researchers returned and asked them to put the big ugly sign on their lawns, most of those homeowners said yes. So why was that so significant? Well, because of the principle of commitment and consistency. The principle of consistency says that people are likely to be consistent with things they have previously said and done. We have a human instinct to want to be and appear to be consistent. Now, the principle is triggered by small initial commitments. It matters if those commitments doesn't matter how small they are. It matters if they're in writing. So the joint petition helps to establish a written commitment towards settlement, towards the encouraging of settlements. And these are things that we know from social science. These are things that marketers know. It's that foot in the door technique. You place a small order in order to get the bigger order later. And it's things that negotiators know in terms of that initial offer and how impactful that can be to your ultimate settlement. Families are impacted by the joint petition. We think that they will be the most impacted by this joint petition process because it supports healthy families, it supports peaceful co-parenting relationships, it helps bring the temperature down at the early stage by setting things up in a non-litigious, non-adversarial manner. And finally, practice. By helping to support settlement, by helping to bring the temperature down, we are reducing the court's administrative burden of court resources, and increasing the opportunity for agreement. And that's all we have. So
yeah, I just want to kind of go back to something that Jen said, and then we have actually a few minutes to answer some of the questions that some of you have submitted. We think this is a good thing for the state of California and courts in particular, right? The vast majority of court resources are devoted to courtrooms and litigation and judges and court clerks and deputies and everything that goes into research attorneys, everything that goes into the litigation process. And it costs a ton of money for a case to go to trial. If this encourages somebody who otherwise would have ended up litigating to actually get to a stipulated judgment, right? Knowing that there's so many things in the process that can lead to conflict and ultimately trial. But if this is one that starts people off on the right foot, inherently it's going to increase the chances of a stipulated judgment, staying out of court, and at the end of the day, saving the county of Los Angeles and every other county in the state a huge amount of money. I want to get to a couple of the questions that pertain to a few of the things that we were talking about. So somebody asked, in a stipulated judgment, we refer to the parties as petitioner number 1, petitioner number 2. Do we amend the forms as necessary to petitioner 1, petitioner 2 instead of petitioner respondent? So Family Code 2342.5 A1, right? So it's right at the top of the new code section, says that for the purposes of identification on judicial counsel forms, Joint petitioner number one is deemed the petitioner. Joint petitioner number two is deemed the respondent. There simply is no way that the Judicial Council is going to redo every single family law form to adapt to the joint petition. So the code section makes very clear that for identification purposes, it's going to be the traditional petitioner and respondent. There's no way of doing it. I've actually already drafted a stipulated judgment on a case that started with a joint petition, and it's really cool, right? You don't need to necessarily refer to anybody as petitioner and respondent, at least in the body of the judgment. Judicial Council forms, we don't have a choice, but joint petitioner number one, petitioner, joint petitioner two, respondent.
I love this question. It says, what do you do if you want to withdraw a prior filed petition in favor of this joint petition? There is currently no way to withdraw your case and opt into the joint petition unless you're starting it, you're dismissing the action and starting a new case. Again, this is it. The impetus for the project was really, how we start matters. So we can't really walk back into the traditional process or we can't walk back into the new process from the traditional process.
Yeah. So here's another question. If joint petitioner two, wants to file an amended response, does that person need to wait for the petitioner to do an amended petition? And the answer is no. That either joint petitioner, again, FL 720, the notice of revocation of joint petition, but joint petitioner number two can initiate that. And that would be in the form of an amended response, right? Again, going to the labels of joint petitioner one and two, it's an amended response. And, think of it this way. The rules are exactly the same as if two parties had appeared and someone's doing an amended petition response in terms of the rules as far as service, the rules as far as responding to the amended petition or amended response. But either party is free to do it. Nobody has to wait until the other has done their amended petition or response.
I see for those eligible for a joint petition for summary dissolution, when would you generally recommend going that route versus the new joint petition for divorce route, particularly for those with no children? So again, I have not had any cases come to me and that were eligible for a joint petition or a summary dissolution process. I think, generally speaking, those tend to be the simpler cases where people are doing it without attorneys, without their mediators. However, if they are eligible for the summary dissolution process and there are no issues and there are no significant assets, no kids, no support, I don't see any reason why that shouldn't also be a tool in the toolbox. So this isn't replacing joint petition for summary dissolution. It's quite different. But if that is something that is advisable in a particular set of circumstances because it's easy, they've got an agreement and they want the automatic divorce to apply in 6 months with their agreement, then I would certainly have no issue recommending the joint petition for summary dissolution. It's really for those other cases that are now eligible. Excuse me.
Somebody asked another really good question. Is this a way to avoid paying two filing fees, or will there be a fee for making it contested? It is such a good question that Jen and I don't have the answer to it, because the policy regarding, whether there's one $435 filing fee or the $870 filing fee as if they had done a petition response, that's wholly left up to the counties. And it really is a good question, right? Because if somebody starts with a joint petition process and the county chooses to charge the $435, if it transitions to, a litigated action through the revocation and amended petition or amended response, as far as I know, there's no requirement for an additional filing fee. So again, that's up to the county. But a question that we asked as well, very candidly, we weren't expecting the single $435 filing fee. And by the way, it's not a bad thing at all, right? If the goal is to incentivize people to start their divorces with a joint petition, with an acknowledgement that in cases like this that go to stipulated judgment, the county resources are minimal compared to litigation cases. If that's what they were going for, I think it's great, but it's still a really good question that if it transitions to the adversarial, call it traditional process, does it make sense that only one $435 filing fee was paid? And that's something that I can't answer, but we'll see what the court ends up doing with that.
There was a question, is the order of proof based on the filing or service of the amended documents? You stated both in your presentation. If we did, we apologize. It's the order of proof is determined pursuant to the date of service of the amended petition or amended response.
Does the court automatically set a mediation appointment if there are children involved? The answer is no, right? As I understand it right now, conciliation court, the appointments are required if somebody files a request for order, and there's no automatic mediation scheduled by the court, as far as I know, once somebody files a joint petition.
Strategically speaking, given that only 20 to 25% of parties hire lawyers, and they do this because they anticipate legal issues, are there reasons other than the filing fee to use this form rather than filing and serving the petition? And the answer is yes, there are a number of reasons. We went through some of them in our presentation. I hope we've answered that. So there are a number, it's again, another tool in your toolbox for strategy, not simply tactic, in terms of how you'd like to approach your case or how your client would like to approach their case in order to get the best possible result at settlement.
This isn't a question, it's a comment, but I like the comment, so I'll read it. The summons redacts the language "you are being sued," applause. And I like the comment because I totally agree with it. This impacts people, right? We can't forget that most people who filed for divorce are self-represented, right? They're either working with, a place like the Family Law Information Center, places like the Buhai Center, Levitt Quinn work with a lot of lower income people. Most people can't afford to have counsel when a divorce starts. And reading it, in English and Spanish, the "you are being sued," it's scary. And, I get it. People need to be on notice that this is a real legal proceeding. With an FL 100 and the traditional summons, they need to know the requirements to respond or be at risk of a default being taken. But those words, "you are being sued," is a scary thing for a lot of people. And, again, the fact that people can start a case on equal footing, they can both appear, no service requirements, and even the elimination of the language "you are being sued" on the joint summons, we say is a really meaningful thing for a lot of people.
How do you title the parties and stipulations under a joint petition? They would be Joint Petitioner 1 and Joint Petitioner 2.
Yep. The only change would be if they're using judicial counsel forms, that's where it's listed as the traditional petition respondent.
We haven't quite gone in order. I'm not sure if we have any other questions on here. Do you see any, Jeff?
I think that we covered pretty much all these questions. If anybody has any additional questions, always feel free to reach out to us. We worked on this project for several years, right? Like I said, it was something that we found in our practices was sorely needed and never existed in our state, even though something like this exists in other places. And that's why we did it. We learned that in the state of California, creating a new process and new forms and court staff and clerks coming up to speed, it's a big deal, right? Whenever a new process is created. We think this is pretty straightforward, and hopefully after this presentation, everyone's clear as to how all of this works. But it is a brand new process. And, we'll see, the question about the filing fees is a very good one, because things like that can evolve over time. That really is up to the individual courts, and they'll set that. But it's a new process. It's an exciting process, hopefully one that a lot of people will use. I'm a mediator, so, in my 1 month sample size, people love it, right? It's a wonderful way to, start a very difficult process.
Thank you. Thank you for having us.
Thank you for having us. And if anyone has any questions, feel free to reach out to Jen or I directly when you fill out your first joint petition if something comes up. We'd rather be the ones trying to answer the questions about it than people kind of guessing. But again, I think most of it is pretty clear in the code section. Everyone should go back and take a look at 2342.5 because it really does answer a lot of questions. But if anyone, has any additional questions, always feel free to reach out to us.
Alrighty, well, this concludes today's presentation. Thank you so much, Jennifer and Jeffrey, for an excellent presentation. Thank you again to our audience and have a great day, everybody.
Thank you.
Thank you.